Hello, good evening, and welcome to Unacademy. Welcome to Conquer Prelims 2026, Stage 1. And in Stage 1, we will discuss current affairs of the period January till December 2025. In yesterday's session, we covered important current affairs topics from Indian polity, which appeared in various newspapers between January to June 2025. And in this session, we will discuss current affairs topics which appeared in different newspapers during this period, July to December 2025. Please do not forget to like this video and subscribe to our channel if you haven't yet. Let's get started and let's look at topic number one, delisting of political parties. There is one law which deals with the entire conduct of elections in India, and that is Representation of the People Act 1951. In this law, there is section 29 capital A, and it is this section which talks about registration of political parties. Now, listen to me carefully. What is a political party? A group of people who come together with the primary intention of capturing power, with the primary intention of contesting elections, and through democratic means form the government, capture the power. Which means for a group to be called a political party, they should contest elections. They should not be against elections. Now, is it necessary? And you tell me in the comment section. Is it necessary for a political party to be registered with the Election Commission of India and then this political party can contest elections? No. But if you want the benefits, then you have to register with the Election Commission of India. And what are these benefits? Tax free donations. Long story short, for a political party to receive the benefits, it has to register with the Election Commission of India under Section 29 capital A. And all these political parties, we say these are registered political parties. Now, over a period of time, once you fulfill various conditions, then some of these registered political parties will be designated as recognized political, recognized as the state political parties or the national political parties. But that is the static part of your syllabus. My point is, please revise what are the criteria in order to be designated as a recognized political party, whether at the state level or at the national level. But listen to me carefully. Why is this important? Election Commission of India has the power to register a political party. Does Election Commission of India also have a power to deregister a political party? No. Yes, there are some conditions which we will discuss, but mostly Election Commission does not have the power to deregister a political party. Now, when a political party wants to be registered with the Election Commission of India, it has to also submit a declaration. And the declaration should say that we will abide by the principles of socialism, secularism, and democracy. And we will uphold sovereignty, unity, and integrity of India. So once you submit your application that I want to be registered as a political party with the Election Commission of India, you also have to declare that I will uphold democracy, socialism, secularism in India, and that I will uphold unity, integrity, sovereignty of India. And then you may be registered with the Election Commission of India. And all these political parties which are registered with the Election Commission of India, we call them registered political parties. But then some of these political parties may be recognized as national or state political parties, and we call them recognized political parties. Now, the point is important facts. Can government companies donate money to political parties? No. So, political parties can receive donations from individuals, from corporates, but can government companies donate to the political party? No. Can a political party receive donation from a foreign company, from a foreign source? No. That would be violation of FCRA, Foreign Contribution Regulation Act. But listen to me carefully. If there is a foreign company but this foreign company has subsidiary in India. Can this subsidiary of a foreign company donate money to political parties? Yes. Although initially it was not allowed, but later on the laws were amended to allow the subsidiary of a foreign company to donate money to political parties. Now, as soon as you are registered as a political party, you can receive donations. Every political party also needs to appoint a treasurer, and it will be the responsibility of this treasurer that you have to disclose the details, the particulars of those individuals and those companies which have donated in excess of 20,000 rupees to political parties in one financial year. And if you have received these donations, no matter what donations you have received, all these donations are tax free. You don't have to pay tax as a political party. But there is a condition. Just like individuals, you and me, we file income tax returns. Similarly, these political parties also will have to file their returns. Now, if a political party fails to file this return with the income tax authorities, then they will have to pay tax. And this is why it was in the news when Congress party was slapped with tax notices by the income tax authorities, because the treasurer of the Congress party failed to submit income tax returns with the income tax authorities. So these are facts which are very important for your examination. But why else was this in the news? Election Commission of India in its notification said that there are close to 2,800 registered but unrecognized political parties. These are registered but unrecognized political parties. And more than 750 of them contested the 2024 elections, which means majority of these political parties, they are not contesting elections. I told you the definition of a political party, that a group of people who come together with this intention of contesting elections and forming the government, capturing political power. Now, majority of these registered and recognized political parties, they don't contest elections. Then why is it that they don't contest elections? We call them letter pad parties. So maybe their primary intention is to receive donations, not contest elections. So maybe you are used as money laundering tools. And to track them, to have a crackdown on these political parties, Election Commission of India started a campaign known as delisting of political parties. But please keep this in mind. Delisting is different. Deregister is different. Can an Election Commission of India deregister a political party if the political party is not contesting elections? No. Can Election Commission of India deregister a political party if there is no inner party democracy in that political party? No. Can Election Commission of India deregister a political party if it has failed to lodge the returns with the income tax authority? No. Election Commission of India has the power, according to the Supreme Court judgment, that you can deregister a political party only under extreme circumstances. If you have obtained registration through fraud, or the political party declares that we don't owe allegiance to the Constitution of India, or my political party was declared unlawful by the central government under Unlawful Activities Prevention Act. Under these circumstances, the court has said Election Commission of India has the power to deregister a political party. So if there is a question in your examination, according to the Representation of the People Act, Election Commission of India has the power to deregister a political party if the political party has not contested elections in the last 10 years. This statement is incorrect. Election Commission of India does not have the power to deregister a political party only because that political party is not contesting elections. Election Commission of India can deregister a political party according to the Supreme Court because of these reasons. Clear? But what Election Commission of India has done, it has started delisting these political parties. Now, what is this delisting? Now, listen to me carefully. 345, you don't have to remember this number, but just for the explanation so that it remains in your mind. Election Commission of India has identified that there are 345 registered, unrecognized political parties, but we could not locate their physical address anywhere. So we want to get in touch with them, ask them, why are you not filing election income tax returns, or why you are not contesting elections. We want to send them notice, but their physical addresses are not found. Now, till the time they will come to us that this is our physical address, we will delist them. When we say we will delist them, that means now if they are not listed as political parties, they will not get the symbol. Now, when they are not delisted as political parties, they will not have access to free symbols, which is given by the Election Commission of India, which primarily also then means that maybe they will not be in a position to raise donations because they have been delisted by Election Commission of India. So, long story short, this topic is in the news under Section 29 capital A of the Representation of the People Act 1951. Election Commission of India registers political parties. And after your registration, if you are unable to contest elections, if you don't contest elections, you don't file returns, can Election Commission of India deregister you? No. But you can be delisted. That means you're no longer in the list of the political parties, which means you will not be given symbol, you can't raise donations. Law Commission of India has said in its 255th report way back in 2015 that if a political party fails to contest elections for the last 10 consecutive years, they should be deregistered. But it is only a recommendation. That is why I told you, if there is a statement in the examination that ECI can deregister a political party if it has not contested elections in last 10 years, this statement is incorrect because it was only a recommendation of the Law Commission of India. In fact, Election Commission of India, in its memorandum on electoral reforms way back in 2016, had suggested that there should be an amendment to the Representation of People Act. Explicitly, power should be given to us to deregister a political party. But Representation of the People Act explicitly does not give the power to the Election Commission of India to deregister a political party. That is topic number one. Any doubts, please let me know, and then we can continue. Okay. Then we have topic number two, limbs, which is the biggest litigant in the courts. The union government, which files the highest number of cases and against whom the highest number of cases are also filed. There are crores and crores of cases pending in the courts. And if the biggest litigant is the union government, we need to effectively control the government litigation. Normally, what is happening? One department of the government files a case against another department of the government. One department of the government files a case against you. Or if you have won a case, they will file an appeal. Mechanically, they keep on dragging these cases. And hence, Law Ministry has said, issued a directive for the efficient and effective management of litigation by Government of India. The proposal is, the intention is that we want less number of cases to reach the court. We need to find other alternatives to resolve the disputes. And mechanically, we should not be filing appeal after appeal because then the pendency of the cases increase and there are crores of cases pending before different courts in this country. What the Law Ministry has done, it has decided, for example, I'm a lawyer. I have been empaneled by the department of a government and the department has lost a case. I will advise the government that we will go for a review. Let's approach the High Court. Let's approach the Appellate Tribunal. Let's approach the Supreme Court because I will get more money if more cases are assigned to me. Law Ministry has done and said that we are going to review these lawyers who have been empaneled by us. We will evaluate their performances, whether they are winning the cases or not, or whether they are mechanically suggesting us that we should file an appeal. This is how we can restrict the government litigation and pendency of the cases will reduce. And for that, there is an important tool known as LIMS. What is LIMS? The Department of Legal Affairs, Ministry of Law and Justice, in association with National Informatics Center, together with NIC, they have implemented LIMS in all the ministries of Government of India, all their departments. their attached offices, autonomous bodies as well. So this is what we call LIMS. It is basically a tool, an online portal which gives us visibility of what is the stage at which this present case is running. So full visibility of the cases filed by the union government and their departments against the union government and their departments, so that we can know at what stage is this particular case. Full visibility is given to all the ministries, all the departments of the central government. And for that, there is this LIMS initiative. And this is used to monitor the cases 24/7 so that there is more transparency. This is LIMS. And for prelims examination, it has been implemented in all the departments. It is an initiative of the Department of Legal Affairs, Ministry of Law and Justice. Clear? That's topic number 2. Topic number 3, Central Board of Film Certification. In the news because of Thug Life, because of Homebound, so many issues, and this topic becomes important. And there are some controversial things also which have happened over the last 1 year that makes this a potential question for your prelims examination. What is CBFC? It's a statutory body created under the Cinematograph Act of 1952. And it works under the Ministry of Information and Broadcasting. This fact you have to keep in mind. In India, films can be streamed or films can be exhibited only if the CBFC has approved its release. And this has been vetted by a Supreme Court judgment, K.A. Abbas. And that is relevant for main, so we will not touch that aspect. You have to keep in mind, CBFC is a statutory body under the Ministry of Information and Broadcasting. When we say a statutory body, that means it is created by the law enacted by the Parliament. And which is that law? Cinematograph Act of 1952. Without the certification issued by CBFC, no film can be released in India. But what is the composition of CBFC? It consists of non-official members and a chairman. Mr. Prasoon Joshi is the chairman of CBFC. All of them are appointed by central government. Where is the headquarter? The headquarter is in Mumbai. But the CBFC has 9 regional centers as well. These facts are important. Regional offices, 9 regional offices. These regional offices are assisted in the examination of the films by advisory panels. For example, there is a Kannada movie which needs permission, which needs certificate to be exhibited in Karnataka and in other parts of the country. For that, you have to approach the CBFC. Instead of approaching Mumbai, you can approach the regional office of CBFC in Bangalore. And then this office will be assisted by advisory panels, those people who will watch this movie and then decide what certificate to give to this movie. And these members of the advisory panel also, they are appointed, nominated by the central government. For what period? For a period of 2 years. These facts are very, very important. But now let's look at most important facts related to CBFC. Under the cinematograph rules, this board, CBFC, must meet every quarter. If this is a statement in your examination, it is a correct statement. But the existing CBFC board that we have last met in 2019. That's why it is controversial. The last annual report of the CBFC dates back to 2016-2017. But the rules mandate that CBFC has to submit annual report with the government annually, every year. But the last annual report, if you can check the CBFC website, dates back to 2016-2017. Hence, it is in the controversy. The board needs to be constituted for a period of 3 years or until further orders, whichever is earlier. That means the board, CBFC, once it is constituted, its tenure is 3 years or until the further orders, whichever is earlier. That means the maximum term of a board is 3 years. But Mr. Prasoon Joshi, Vidya Balan, Vivek Agnihotri, and others who have been nominated and appointed to the CBFC, they were appointed in 2017 and we are in 2026. And that is why Indian Express came up with a detailed expose on CBFC and said we are raising serious doubts about CBFC's legal status, whether it is legally valid or not, because the term is 3 years and new members have not been appointed, new chairman has not been appointed. Hence, it is in the controversy. So keep these statements in mind. But in 2024, major changes were made to CBFC rules. Online certification process started. So you can apply for CBFC certificate online. And when you do it online without any manual interaction, the process is transparent. Previously, we would have four certificates: universal for all age groups, A for adults, S for specialized category. Now, in 2024, they said, let's introduce age based certification categories. That this is not valid for less than 7, 13 plus people only can watch, 16 plus people only can watch. So these category based, age based certification categories were provided in 2014, 2024. Before that, it was not available. It was universal, adult, specialized, and where parental guidance is necessary below the age of 18. Mandating greater representation for women. 2024 rule said we need to ensure gender parity in the composition. Hence, at least one third of the members of the CBFC shall be women. There was a time when CBFC license or certificate was given for 10 years. Now they give certificate for perpetual validity. That means you don't have to renew your certificate. And if you want your movie to be screened earlier, on priority, for that you have to give an additional fee. And on priority, we will watch your movie and then decide what category certificate to give to your movie. These 2024 changes are very, very important. That completes our topic 3, CBFC. Any questions, anyone? Is CBFC mandatory for OTT? No, CBFC does not deal with OTTs. Good question. Reservation in the Supreme Court. Now, you tell me, is there reservation amongst the judges in High Court and Supreme Court? No. Appointment to High Court and Supreme Court judges is done by the President of India based on the recommendations of the collegium system. That is something that you all must be aware of, right? But in Supreme Court, specifically Supreme Court, there are non-judicial posts. Apart from judges, there are other officers. For example, librarian, court assistants, court attendants. For these posts, for the first time, reservation has been proposed by the Supreme Court, because Supreme Court has the power that it can decide your own rules when it comes to your recruitment. If you have to recruit members to the Supreme Court, for that you decide your own rules. Supreme Court will decide. And when Justice Gavai was the Chief Justice of India, rules were made, and for the first time, reservation was provided to these Supreme Court posts for SCs and STs. Not just in recruitment, but also in promotion. But only for SCs and STs, not for the OBCs. Why? Let's not get into that. Just keep this fact in mind. Or maybe if you want to know that, the Supreme Court Chief Justice said, we have a clarity. Because this is the central list of SCs. This is the central list of STs. But when it comes to OBCs, there is no common central list of OBCs. There may be some OBCs who will be part of the central list, but some OBCs will be part of the state list. That is why, unless and until we have a clarity on the class of OBCs, we will not extend reservation to OBCs in Supreme Court posts, but we will have reservation in the recruitment as well as in promotion for the members belonging to SC and ST community. This is topic number 4, very important. Topic number 5, Nalsa. There was a doctor in Manipur, born as a man, but then because of the change of gender, you decided to change your gender, she became a woman, a doctor. But now she had to get her gender changed in the certificates given by the medical university, given by the school, higher secondary school. They all dilly-dallied, and ultimately matter went to the Manipur High Court, and a landmark judgment was given for the first time, where on the directions of the court, these authorities were told, change the gender of this individual, because self-identification of a gender is something that we have guaranteed in 2013. Because in Nalsa v. Union of India 2013 case, the Supreme Court recognized transgender as the third gender. And for that, Supreme Court said self-identification. You don't have to necessarily go through sex change surgeries or gender change surgeries and then you can decide to change your gender. No, you identify yourself with a gender, self-identification is the key, that is part of your rights. And in the same judgment, the Supreme Court had directed that the members of the transgender community, they are socially and educationally backward. And when they are socially and educationally backward, that means the Supreme Court directed that affirmative action policy should be created for them. And what do we mean by affirmative action policy? Reservation in government jobs, reservation in educational institutions. And for that, Transgenders Act was enacted by the Parliament in 2019. But the reservation which was directed by the Supreme Court was not provided to them. And in fact, this law of 2019 makes it difficult for these transgenders to identify themselves as a transgender. Because for that, it necessarily means that you need to go to a district collector and get the certificate of change of gender. Long story short, Nalsa v. Union of India 2013 judgment recognized transgender as a third gender in India. The Supreme Court recognized that these are socially and educationally backward classes of citizens and as such deserving of the affirmative action policy. Now, because of this judgment, Transgenders Act was passed in 2019. But according to this law, self-identification also is not enough. Court judgment says self-identification. You identify with a gender, that's your gender. Even without resorting to gender uh, surgeries or gender corrective surgeries. But here, according to this law, you need to get the certificate from the district collector and petition the district collector from where you can get the certificate. Self identification alone is not necessary. You need to get the approval of the government. For that, let's look at this question on your screen. You tell me what is the right answer. Which of the following statements correctly describe the constitutional, statutory, and Supreme Court provided rights of transgender persons in India? The Supreme Court of India in Nalsa judgment recognized transgender persons as third gender and affirmed their right to self-identification of gender independent of any medical or surgical procedure. You don't have to necessarily resort to gender corrective surgeries to identify with yourself with a gender. No, even without that, self-identification is the key. Transgender Persons Protection of Rights Act 2019 prohibits discrimination against transgender persons in educational institutions and employment, but it does not recognize the right to reside in one's household. No, you have a right. If you're a transgender person, the one drawback that you frequently encounter is that your family disowns you and you are thrown outside of your house. The Supreme Court recognized this, that this is the torture that they will have to face. So you have a right to reside in your own household. That's your right. So this law, it recognizes the right to reside in one's home. So this statement is incorrect. Under the Indian Constitution, only Articles 15 and 16 expressly guarantee transgender rights. Article 14 does not apply to them. Transgenders are explicitly not given protection under the Constitution. But that does not mean that Article 14 will not apply to them. Article 14 applies to anyone who is residing within the territory of India, regardless of sex or sexual orientation. That's why the statement is incorrect. The Supreme Court has held that freedom of expression under Article 19(1)(a) does not extend to transgender persons' attire or self-presentation. The attire of transgender persons, the dress that they wear is different. Including that is protected by the law, protected by the constitution. That is considered to be part of your expressions, how you express yourself, the kind of dress that you wear. That's protected by the constitution. So this statement is wrong. So first statement, A, is the right answer. Clear? Good. Topic number 6, removal of judges. Now, Justice Yashwant Verma may become the first judge in the history of independent India to be removed by the president based on the resolution passed by both houses of the parliament. That we all know. So this topic becomes important. Also because this matter is before the court. Why? Listen to me carefully. Who will remove a judge? Whether the judge is of a high court or a supreme court? President. On what grounds? Proved misbehavior or incapacity. Misbehavior can be corruption allegations, such as against Justice Yashwant Verma. Incapacity, maybe you have turned insane. We have due sympathies with you, but we cannot entrust you with the responsibility of granting justice to others because now you don't have that mental capacity or capability to function as a judge. But are these terms, proved misbehavior or incapacity, defined in the Constitution? No, not defined in the Constitution. Clear? But the procedure is defined where? In a law known as Judges Inquiry Act 1968. And this is where it becomes important. Listen to me carefully. How can a judge be removed? The process may initiate in Lok Sabha or the Rajya Sabha. If 100 members of the Lok Sabha write to the speaker, or if 50 members of the Rajya Sabha write to the chairman that we want to remove a particular judge because of proved misbehavior or incapacity, there has to be an investigation by a committee. But who will constitute this committee? Listen to me carefully. If this motion has been accepted in this Lok Sabha by the speaker, speaker will set up this committee. If this motion was introduced in Rajya Sabha, accepted by the chairman of the Rajya Sabha, the vice president, so this committee will have to be set up by the chairman of the Rajya Sabha, the vice president of India. But now listen to me carefully. What if on the same day, both in Lok Sabha as well as Rajya Sabha, a motion is introduced, and on the same day, both chairman as well as the speaker accepts this motion? Then in that case, who will set up this committee? This committee will have to be jointly set up. Jointly set up. And that is what happened with the removal of Justice Yashwant Verma. It is argued that on the same day, motion was introduced in Lok Sabha as well, motion was introduced in Rajya Sabha as well. And somehow the Rajya Sabha chairman, he was not supposed to accept this motion because the government wanted this process to initiate in Lok Sabha. And that became the trigger, and Vice President of India, Mr. Dhankar, suddenly resigned, citing health grounds. But keep this in mind. And later on, the government said, Lok Sabha said, that this motion was not accepted by the chairman. So when it was not accepted by the chairman on the same day, it was accepted only by the speaker of the Lok Sabha. So now the speaker of the Lok Sabha has set up this investigation committee. And this investigation committee will have 3 members. There will be a judge from the Supreme Court. There will be one Chief Justice of a High Court, and there will be one eminent jurist. Together, they will decide whether the charges leveled against a judge of proved misbehavior and incapacity, whether these charges are correct or incorrect. But is the speaker or the chairman bound to accept this motion? No. In 2017, when Chief Justice of India Deepak Misra was sought to be removed by the opposition, more than 50 MPs of Rajya Sabha wrote to the chairman of the Rajya Sabha that we want to remove the Chief Justice of India. The chairman, Mr. M. Venkaiah Naidu, who was the Vice President of India, did not accept this motion. So there is the discretion of the speaker or the chairman. He may or may not accept this motion. But once you accept the motion, then you have to get these charges investigated by this committee. And then whatever report is presented by this committee, both houses of the parliament will have to act. But is the report of this committee binding? The report of this committee is not binding. It's for the parliament to decide whether this is to be acted upon or not, whether we will vote or not, whether we will vote in favor or vote against. That's something that you have to keep in mind. And Justice Yashwant Verma, through his lawyer, Mr. Mukul Rohatgi and others, they have approached the Supreme Court. They have challenged the very constitution of this investigation committee on whatever grounds that we don't have to cater to irrelevant for your exam. But what is relevant is removal of a judge. Who removes? On what grounds? What is the procedure? And whether the report is binding or not. These are the facts that you have to keep in mind, extremely relevant for your upcoming prelims examination. Now let's come to topic number 7, section 152 of the BNS. There used to be section 124 capital A of Indian Penal Code, which dealt with sedition. Matter was before the court. Long story short, the court said stay. No further arrest under sedition, because we have to decide whether sedition law is constitutional or not. And when the matter was pending in the court, IPC was replaced by the Bharatiya Nyaya Sanhita, and now Bharatiya Nyaya Sanhita does not have any provision for sedition. Instead, what is there in BNS? Section 152 of the Bharatiya Nyaya Sanhita. And what is the section? Whosoever, through words, whether spoken or otherwise, if you are promoting secession, armed rebellion, subversive activities, separatist activities, or through the use of financial means, whatever you're doing, if you are using counterfeit currency to excite separatism from India, that is also a crime under section 152 of the BNS. So section 150 of BNS, some people say, is equivalent to the sedition law of the erstwhile Indian Penal Code. And there is a challenge before the Supreme Court against this section as well. But you may be asked to identify what are the specifics of section 152. If you promote or if you attempt to excite secession, armed rebellion, subversive activities going against the sovereignty, integrity of India. So previously, sedition was against if you promote disaffection against the government. Section 152 does not criminalize disaffection against the government, but disaffection against the nation. So previously it was Rajdroh, offense against the government. Now it is Deshdroh, offense against the nation. That's the difference between the two. But be that as it may, Supreme Court also has clarified in numerous verdicts, whether Kedarnath, Balwant Singh, Shreya Singhal, that no matter how inflammatory the speech is, how radical the speech is, unless and until you are inciting people to violence, unless and until you incite people to violence, you're not a criminal. So there has to be violence after the speech that you have given. Unless and until there is violence, you will not be booked under sedition. You should not be booked under section 152 either. But now the important matter. Overbreadth doctrine. Listen to me carefully. Why we are discussing this? If there is an ordinary law, and what do we mean by an ordinary law? Bharatiya Nyaya Sanhita is an ordinary law. Right or wrong? Right. Can this ordinary law be challenged in the courts? Yes. On what grounds? Two grounds. Ground number one, if this law is a violation of fundamental rights. Second, if it is beyond the legislative competence of the authority which enacted such a law. So, can an ordinary law be challenged in the court of law? Yes. On what grounds? If this law violates fundamental rights. Second, if the body which has enacted this law does not have the legislative competence. For example, Karnataka Legislative Assembly enacting a law on currency, but currency is in the union list. How can Karnataka legislature enact a law on an item which is there in the union list? Or Parliament enacting a law on, let's say, police, but police is within the domain of the states. How can Parliament enact a law on the state list? On these grounds, and the fact that a law or the allegation that a law violates fundamental rights, on these grounds, ordinary laws can be challenged. There can be a question, a statement in your exam. Can an ordinary law be challenged on the grounds of misuse? A law is being misused, a law is being weaponized. Whether the law is Prevention of Money Laundering Act, Unlawful Activities Prevention Act, NIA Act, whatever, can an ordinary law be challenged in the courts on the grounds that these laws have been misused, overused, hyperused, abused? No. Only on these grounds ordinary laws can be challenged. And sir, what about ordinary laws and what about constitutional amendment acts? These constitutional amendment acts can be challenged in the courts on the grounds of violating basic structure. Can an ordinary law be challenged on the grounds of violating basic structure? No. Now there is something called overbreadth doctrine. This is where it becomes interesting. For example, my company wants to enact a law. Let's assume my company is the parliament and my company wants to protect my dignity. And what is that dignity? You can't be leveling allegations against me that sir takes money to evaluate the answer or sir takes money to teach separately. I don't do that. So if you are making these statements, my company legislature will enact a law and you are a criminal. And what is that law? Law says you should not, as a student, say anything which goes against the dignity of a teacher. So the phrase used by this law is don't say anything which affects the dignity of a teacher. Because if you're saying sir is taking money, it affects my dignity. This should not be allowed. But what if you say sir never comes on time? Sir wastes our time. Sir teaches only for prelims and not for mains, or teaches only for mains and not for prelims, or does not teach at all, teaches irrelevant stuff. Company may say this allegation against this teacher also affects my dignity. But this is your right. You should say this if I'm wasting your time, if I'm not teaching according to the requirements of this exam. So if there is a law, listen to me carefully, if there is a law which criminalizes protected as well as unprotected free speech, this is a protected free speech where you can criticize me if I'm wasting your time. This is unprotected free speech if you are leveling false allegations against me. If a law's language is so vague, dignity of a teacher, that it can criminalize protected as well as unprotected activity, this law can be declared unconstitutional. The law is vague, and for its vagueness, the law will be declared unconstitutional. And this is what we call chilling effect. So can an ordinary law be challenged on the grounds of its vagueness? Yes. Because if it is vague, it means it is arbitrary. And if it is arbitrary, it violates Article 14. And Article 14 is a fundamental right. Clear? These are the facts that you have to keep in mind. Very good. Topic 8, free speech. Now, what Mr. Samay Raina said on his India's Got Latent, or what Ranveer Allahabadiya said, or what others have said, free speech has been in the news. But for the prelims examination, you may not be asked about the controversy. What you may be asked about, what are the reasonable restrictions on your free speech. How many restrictions are there? Article 19(1)(a), which talks about freedom of speech and expression, is not absolute. There are reasonable restrictions. How many reasonable restrictions? 8. But are you aware that there weren't these 8 reasonable restrictions in the original constitution? Originally, these were the 4 reasonable restrictions, just 4. Security of the state, decency or morality, contempt of court, defamation. These were the only 4 reasonable restrictions on your free speech. Others got added later. So when first amendment of the constitution took place in 1951, 3 more grounds were added under Article 19, Clause 2. Public order, friendly relations with foreign states, incitement to an offense. And the 8th reasonable restriction, 16th Amendment in 1963, added sovereignty and integrity of India. So these facts are important, can be important for your exam. Originally, there were 4 reasonable restrictions. 4 got added later through constitutional amendments. 3 via first constitutional amendment, sovereignty and integrity of India were added in 1963, 16th Amendment. That's topic number 8. Topic number 9, Corrupt Neta Bill. 130th Constitutional Amendment Bill. Let's quickly go through what this bill is all about and you're done. We don't have to overanalyze this bill, whether this bill is good, bad, ugly, so on and so forth. That is the remit for the mains examination. For prelims, let's look at the specifics and be done with this. What this constitutional amendment bill tries to do, it tries to amend few articles of the constitution with regards to Union Council of Ministers, with regards to State Council of Ministers, with regards to Council of Ministers in Union territories. Because we have a parliamentary system at the union level, state level. So at union level, we have Prime Minister and Council of Ministers. At state level, we have Chief Minister and Council of Ministers. At union territories level, those union territories, 3 of them, Delhi, Puducherry, J&K, which have a legislative assembly, and they have their chief ministers and the Council of Ministers, it is for them that we have 130th Constitutional Amendment Bill. Now, what is this bill? If I'm a minister, but as a minister, I have been arrested. On what charges? Any charge for which the imprisonment is 5 years or more. I am a minister. Now I have been arrested. For example, Mr. Kejriwal was arrested. Mr. Senthil Balaji was arrested. Mr. Manish Sisodia was arrested. Mr. Satyendra Jain was arrested. So many individuals were arrested. Ministers were arrested. Now for that, the bill was brought. If there is a minister who has been arrested by the agencies, by the police, for an offense for which, if you are convicted, you will have to serve 5 or more years in jail. You have to resign. Once you have stayed 30 days in jail, you have to resign. Now, if you don't resign, on the 31st day, Prime Minister will have to recommend to the President, please remove him. Now, on the 31st day, if Prime Minister does not recommend to the President, remove him, on the next day, which is the 32nd day, the President will remove that minister. This is this bill. I'll summarize again, repeat again. I am a minister, but now I have been arrested and I am in the jail. And if I remain in jail for 30 days, under what allegation? If the allegation is that I have committed a crime for which, if I am convicted, when I am convicted, I will have to serve 5 or more years in jail, then I have to resign after the 30th day. If I don't resign, then Prime Minister will have to advise the President, please remove this minister, because there is doctrine of pleasure. And what is this doctrine of pleasure? That a minister holds office during the pleasure of the President. Individual responsibility, and which ideally means the pleasure of the Prime Minister. But if the Prime Minister is not advising the President to remove this minister who is in jail for the last 30 days, on the next day, the President will remove that minister. That is 130th Constitutional Amendment Bill, known as Corrupt Neta Bill. Clear? Whether this 30-day is arbitrary or non-arbitrary, that is the analysis of this. We will discuss it in the mains examination. Topic 10, Saha guidelines. Can anyone tell me in the comment section, Saha guidelines deals with what? Posh, mental health. Very good. Mental health. In Sukhdev Saha, v. State of Andhra Pradesh 2025, Supreme Court said mental health is an integral component of right to life, which means it is a fundamental right under Article 21 of the Constitution. So, for the first time, explicitly, Supreme Court has said right to mental health is a fundamental right under Article 21 of the Constitution. And if you look at the PYQs, right to privacy, multiple times asked in the prelims examination, is under which of the following articles of the Constitution? Article 21. Similarly, prohibition of untouchability deals with which of the following fundamental rights? Right to equality. So such questions are asked in the examination. So right to mental health, or once the question was asked, right to marry, immediately after the in the prelims 2020 examination, right to marry comes under which of the following articles? Article 21. Similarly, right to mental health. There are some straightforward questions. Right to mental health comes under which of the following articles? That is Article 21. Previously, for example, in Shatrughan Chauhan, Navtej Johar, Supreme Court had recognized mental integrity, psychological autonomy. For example, in Shatrughan Chauhan case 2014, Supreme Court said if there is somebody who is on death row, who is to be hanged, but this person is suffering from mental illness, for example, schizophrenia, this person should not be hanged. His death sentence should be commuted to life imprisonment. Similarly, in Naute Johar, Supreme Court spoke of autonomy. And if somebody is suffering from mental illness, mental sickness, you don't have psychological autonomy. So psychological autonomy is an integral part of your mental health. And now Supreme Court has went a step further, expanded the scope of Article 21 and has said right to mental health is a fundamental right under Article 21 of the Constitution. But with regards to mental health, what are the steps taken by the government? These can be important statements in your prelims examination. For example, at the school level, we have Umeed. What is Umeed? Understand, motivate, manage, empathize, empower, and develop. What are these guidelines for? To prevent student suicide. Who released these guidelines? Ministry of Education. What are these guidelines aimed at? We need to sensitize schools. We need to identify those students who are at the risk of committing suicides. Because these Saha guidelines were released by the Supreme Court in this case to ensure that there is a decrease or eradication of the rising incidence of suicides amongst the students. And how do we sensitize the schools? We have to identify those children who are at the risk. For example, somebody who has been bullied in the school, he or she is at the high risk of committing suicide. And for that, the draft guidelines were released. Understand, motivate, empower, empathize, manage. Similarly, Ministry of Education has launched a portal called Mano Darpan. So Mano Darpan portal deals with which of the following? You need to know it's about prevention of student suicides. Umeed draft guidelines is for providing loan to SMEs, is providing concessional treatment to bread and breakfast, breakfast and bed scheme. So you have to be absolutely sure what are these schemes and guidelines all about. Mano Darpan portal was launched to ensure health and mental well-being of students during COVID-19. So this is where you can book counseling sessions with the mental health care professionals. So, trained professionals will be able to guide you. Emotional well being is to be encouraged because people felt lonely. Students felt lonely during the COVID-19 lockdown. And for that, there was Manodarpan portal. We have some international commitments as well. For example, International Covenant on Economic, Social, and Cultural Rights. It talks about that right to highest attainable standard of physical and mental health. It's the obligation on the states, obligation on the countries. You have to recognize. And for that, we need laws, interventions. United Nations Committee on Economic, Social, and Cultural Rights. It has affirmed that this right includes timely access to mental health services, including suicide. We are a signatory to Convention on the Rights of Persons with Disability. Disability may not only be physical disability, but psychological disability as well. And we need to protect our children from such issues. And that is why we have a Mental Health Care Act 2017, which we were discussing yesterday as well. It has explicitly decriminalized suicide, arguing that those who attempt suicide, they are vulnerable and they need care and protection, support rather than punishment. So SAHA guidelines deal with prevention of suicides among students. What are these SAHA guidelines? Maybe can be relevant, can be asked in your exam. All educational institutions will have to adopt guidelines to encourage mental health amongst the students. And for that, all educational institutions are encouraged that you need to adopt the Umeed draft guidelines and Manodarpan initiative. And every year, you will have to review and update this mental health policy. And you have to give it a prominent space in your notice boards and on the websites. But this will be applicable on those educational institutions with 100 or more, on all educational institutions, but those educational institutions which will have 100 or more enrolled students, they need at least one qualified counselor. And if the number of students increase, corresponding to that, the number of qualified counselors should also increase. Those who can counsel the students why you should not commit suicides. And at the same time, coaching institutes. Maybe a statement is asked in the examination that SAHA guidelines are directed at established educational institutions and exclude coaching centers. No, coaching centers are brought within the ambit of these guidelines because we see in coaching centers that there is a segregation of students. Those who are scoring well in some tests, they are given star batch, some are given China batch, some are given another batch. So if you segregate students on the basis of academic targets, on the basis of the marks that they obtain in the test, this is fueling them into committing suicides and affecting their mental health being. You should not, as far as possible, you should refrain from engaging the batch segregation in the schools and in the coaching institutes. For that, we have SAHA guidelines. And any guideline which is issued by the court under Article 141, we say it is the law of the land. Any order, any judgment, any verdict given by the court under Article 141 becomes the law of the land. Okay? Also, all the teaching as well as non-teaching staff, they will have to undergo mandatory training at least twice a year so that they know how to deal with those students who are at risk, how to counsel them. Topic 11, Article 17. Article 17 says untouchability is abolished and its practice in any form is forbidden. But one important thing that you have to keep in mind, this term untouchability is not defined in the Constitution. When it is not defined in the Constitution, that means we are not looking into the literal interpretation of this word, meaning of this word untouchability. We're looking at the historic practice of untouchability, practiced in India after later Vedic period. Which means untouchability on the grounds of caste. And for that, we have vulnerable sections of the society, SCs and STs. And for them, we have a law called Atrocities Act, Scheduled Caste and Scheduled Tribes, Prevention of Atrocities Act, 1989. You would have discussed this. This is part of your static syllabus. But an important judgment had come in 2018 in Subhash Kashinath Mahajan. It was argued before the court that this law is being misused. Because under this law, there is immediate arrest, filing of charge sheet, FIR, no bail. So it was argued before the court that this law is being misused. And the process becomes a punishment. If this law is misused against me, automatically FIR would be filed. I will be arrested by the police, and it is a non-bailable offense, which means unless and until the court decides that I'm innocent, till that time I won't be released, maybe. If this law is being misused, in Subhash Kashinath Mahajan, Supreme Court said, no, we need to prevent this misuse. And how do we prevent this misuse? No immediate arrest, no automatic registration of the FIR. First, there has to be a preliminary inquiry. An inquiry has to be conducted by the police to see whether this is a case of untouchability or not, or whether it is that there is one section, one person from Dalit community, one person from upper caste community, and they are fighting with each other, and the real person who's responsible for this fight is a Dalit. So it is not a case of untouchability, it's a case of property dispute between them, or maybe a marital dispute, whatever it is. So police will have to first conduct a preliminary inquiry and decide whether this is a fit case for untouchability. Only after that, there should be a written approval, permission given by the DSP or SP, then arrest can take place. Long story short, there was a huge hue and cry, and finally, Parliament amended this law, added Section 18 capital A, and ultimately restored the status quo. What is the status quo? That means right now, if somebody is alleged to have committed atrocity under this act, immediately he will be arrested, FIR will be filed, no bail, and there is no need for any preliminary inquiry. And here the burden of proof is on the accused, which means if I am accused of committing atrocity under this act, I have to prove before the court of law that I am not guilty. Otherwise, in criminal cases, it is the prosecution which have to prove whether I have committed this crime or not. But be that as it may, why this topic becomes important for this exam is because of this judgment, Kiran v. Rajkumar Jivaraj Jain 2025. Why is this important? Listen to me carefully. Untouchability can be practiced in various forms. For example, I'm a Dalit. Upper caste men and women, they tell me that you should vote for this candidate in the election. But I want to vote for somebody of my choice. Maybe I want to vote for somebody who belongs to my caste, but they're forcing me to vote for someone else. And if I don't abide by their directive, they assault me. Isn't this untouchability? Isn't this caste atrocity? And this is exactly what happened in this case. I was a complainant, Dalit. I was attacked outside my home. I was assaulted in full public view. Why? Because I did not resort to the blackmail of the upper caste. I decided to vote as per my own conscience, which was not acceptable to them, and as such, I was assaulted. When I approached the police, the accused person was arrested, but then the court released him on bail. Despite the fact that this is a non-bailable offense, he was released on bail. Why? Because the court said that this seems to be politically motivated case. The allegations that you have leveled in this case, these are exaggerated. We will grant the bail. And when the bail was granted, matter reached the Supreme Court. Supreme Court said, you should not have done this, Honorable High Court. You can't apply prima facie test when it comes to Atrocities Act. What is prima facie test? Prima facie, at the face of it, the Bombay High Court is saying maybe the allegations are exaggerated, inconsistent, fabricated. You should not go into the merits of these allegations because it is a non-bailable offense. And when somebody is being assaulted because of the voting choices that you have made, this is the fit case of untouchability. So prima facie test does not apply to Atrocities Act. It is a non-bailable offense. And these requirements that there should be no immediate arrest, no immediate filing of the FIR, preliminary inquiry by the police, and the written permission of the DSP or the DYSP before arrest can be made, all these are no longer valid. Clear? Okay. Topic number 12, Waqf, was in the news throughout last year, but we will specifically focus on some provisions because there was an interim judgment given by the court, and then leave the controversy aside. First, you need to understand when this law was challenged before the court, and the argument was that this law should be stayed. Supreme Court did not stay the entire law. Why? Because the Supreme Court said we are bound by presumption of constitutionality of the legislation. And this is what we call doctrine of the presumption of constitutionality. What does that mean? That means if a law is enacted by the parliament, listen to me carefully, and this law is challenged before the courts will assume that this law is constitutional. It is for the petitioner to prove that the law is unconstitutional. Keep that in mind. Why? Because the argument is, who has made and enacted this law? Legislature. Legislature consists of elected members of the people. These elected members are accountable to the people. Why would elected representatives enact a law against the people, against their fundamental rights? So we will presume and assume that whenever a law is challenged before the court, we will assume that the law is constitutional. It is for the petitioner to prove that the law is unconstitutional. And since this Waqf law was enacted by the parliament, you have to convince us that the law is unconstitutional. We are not going to stay it. But some provisions were indeed stayed. Stayed in the sense, which were these provisions? For example, if this is a land which is a Waqf land, on this land there is a dispute whether this belongs to government or this belongs to Waqf. Immediately, district collector is empowered to inquire into whether this property is a Waqf property or a government property. And district collector will decide accordingly. So who has the power to decide whether a property is Waqf property or a government property? District collector. But district collector is part of the state, is part of the government. So it is like you are empowering executive, whereas this decision should have been taken by the judiciary. Because there is something called separation of powers. You cannot be taking judicial decisions if you're part of the executive. There is separation of powers, which is part of the basic structure. Number one. Number two, as soon as an allegation is leveled that this property is Waqf property, it's not a Waqf property, it's a government property, it will be denotified from the Waqf property. Then we will decide whether it is Waqf property or not, but till the time we decide, it will be removed from the status of a Waqf property. Who will decide that? District collector. The court said this is arbitrary. This is arbitrary and as such violation of Article 14, and we are going to stay this. There was a requirement that those who want to donate their property to Waqf, they should be practicing Muslims for the last 5 years. Person has to show or demonstrate that he is a practicing Muslim for the last 5 years. Court partially stayed it. Did not completely state, partially. Court said there is no procedure right now which can currently verify whether a person is a practicing Muslim or not. Since such a procedure does not exist, till the time the government comes up with a procedure that this is how we will evaluate and decide whether this person is practicing Islam for the last 5 years or not. Till that time, we will stay this rule. Another issue was having more non-Muslim members in the Waqf board, which the petitioners argued violates Article 26 of the Constitution. Because Article 26 says if you are of any religious denomination, you have a fundamental right to establish institutions, manage institutions, administer institutions, whether these are for charitable purposes or for religious purposes. But if non Muslims will start managing Waqf properties, it would violate Article 26, which is a violation of fundamental right. Supreme Court said, but managing the property is a secular activity. You don't have to necessarily be a Muslim to manage a secular property. But yes, since it deals with religion, what we will ensure is that of all the 22 members who are part of the Central Waqf Council, not more than 4 should be non Muslims, others should be Muslims. In state Waqf boards, if they have 11 members, only 3 non Muslim members can be appointed, rest can be Muslims. And as much as possible, as far as practicable, the chief executive officer should also be a Muslim. But what the court did, it de-recognized the Waqf by user properties, which was mentioned in the law, the amendment to this law. What is Waqf by user? I have to donate my land property to the Waqf. Ideally, what happens is I should donate it legally with proper documentation that now I am transferring this property to the Waqf. And now who is the owner of this property? It's the God. Because I have shifted the ownership as well. I have transferred the ownership as well. There are instances where there are hundreds and hundreds of properties for which this deed is not present, where an individual has donated property to the Waqf but documentation is missing. And in those cases, since these properties were used as Waqf properties for many decades, for many years, we call them Waqf properties by user. That means, long story short, if this is a property, whose property is it? My property. I donated it to the Waqf through proper deed agreement, through proper agreement. It's a Waqf property. But there were 1, 2, 3, 4 properties which we were using as Waqf properties, for which there is no documentation, who donated it, how donated. But since we have been using these properties for eternally, this is Waqf by user. The law said Waqf by user will not be applicable now. There has to be proper registration of these Waqf properties and proper documentation who donated to whom. And at the same time, Limitation Act. This is the last point that we need to discuss. There is a property, and this property is owned by an unknown. We don't know who is the owner of this property. Can you claim this, or for that matter, you are the owner of this property, but you left this country. You assume that this property is safe because you have the documents. But somebody has acquired this property illegally. And now there is a school set up in that property. For how long, till what time can you claim this property? There is something called Limitation Act. You have to claim this property back within 12 years. So there is a 12-year limitation period. After that limitation period is over, you can't claim this property again. Waqf properties were exempt under Limitation Act. That means if there is a property which is being controlled by someone else, even for the last 30, 40 years, you can still as Waqf board petition that we want this property back. Because Limitation Act does not apply to Waqf properties. So we don't have to necessarily wait only for 12, we don't have to necessarily act within 12 years. We can act even after the expiry of this limitation period of 12 years. But now Limitation Act will apply to Waqf properties. You can claim these properties back only within 12 years. After that, no. That's the end of this topic. Okay, great. Supreme Court cites topic number 13, preamble to reject plea against Banu Mushtaq opening Dasara in Mysuru. Now, preamble and the objectives that are mentioned in the preamble, They are part of the basic structure. So please revise preamble topic is again important this year. What is the controversy here? What is the issue here? Banu Mishtaq, who was the winner of International Booker Prize, she had to inaugurate Dasara festival. And against that, a petition was filed in the court that since Dasara festival is a Hindu religious festival, how can a Muslim inaugurate this? This will affect my religious rights. Supreme Court struck down this, dismissed this petition, saying Dasara is a public event. When it is a public event organized by the state and the state is secular, how can the state discriminate on the grounds of religion? So, if this Dasara festival is to be inaugurated by a Muslim, that does not mean that we will have to stop it. Why? Because the festival is a state festival, a public festival organized by this government, which is secular, and as such, we cannot discriminate on the grounds of religion. And Supreme Court cited preamble. Supreme Court said, look at the preamble of the Constitution. It talks about liberty of thought, belief, worship. It talks about secularism. And if the preamble talks about secularism, we cannot be discriminating people on the grounds of religion. And in a pluralistic society such as India, we cannot be discriminating against the citizens. So preamble topic is in the news. Preamble topic you need to revise. Topic number 14, defamation. Defamation case against Sri Rahul Gandhi and various other individuals. Is defamation, let me ask you a few questions. Is defamation a reasonable restriction on your freedom of speech and expression? Yes. But is this defamation only a criminal offense? Or is it also a civil offense? Defamation is both civil as well as criminal offense in India. In Subramaniam Swamy case 2016, Subramaniam Swamy and others, they had challenged the criminal defamation laws in this country. Basically, what is a criminal law? What is a criminal wrong? You are one party, the state is the other party. So a wrong that you commit against the state is a criminal wrong. This criminal defamation law has a colonial history. If the public officials, they were defamed by people, it was the responsibility of the crown, the state, to protect their reputation. And as such, if you are defaming him, I will come to the rescue of this individual because he is my public official. I, as a crown, have the responsibility to protect his reputation. That's how criminal defamation laws originated in India. A civil wrong is a dispute between one and the other individual. Ideally, defamation, if I am defaming you, it should be a matter of dispute between you and me, which basically means a civil wrong. Why should state get involved to protect my reputation? That's why Subramaniam Swamy approached the court and the court said no. The petitioner had argued that please declare that defamation should only be a civil wrong, not a criminal wrong in India. Supreme Court said no because right to reputation is an integral part of right to life and it is the responsibility of the state to protect right to life. And as such, right to reputation. And as such, criminal defamation is a crime. And you would know that in a criminal case, you will be serving time in the jail. You will be imprisoned. But in civil disputes, you only have to pay compensation. So defamation is in the news. Defamation becomes an important topic for your examination. Topic number 15, personality rights. Again in the news. What are these personality rights? What is their legal backing? That is something that you have to keep in mind. The Supreme Court has said, because these personality rights, you have to keep in mind, have evolved through judicial decisions, otherwise not explicitly provided by the Constitution. These personality rights have evolved through judicial decisions. But what are these personality rights? There are two dimensions of these personality rights: publicity rights and privacy rights. For example, there is a celebrity. Shah Rukh Khan, Virat Kohli, so on and so forth. Can I display that Shah Rukh Khan has endorsed Unacademy's platinum program and you should also enroll in the platinum program? I am using the personality of Shah Rukh Khan to campaign for my classes, which leads to monetary loss for Shah Rukh Khan, because otherwise he would have asked for crores of rupees to endorse this program. So if you are using one's name or likeness or image and unauthorizedly, without his approval, exploiting it for commercial gain, you are violating his publicity rights. Similarly, privacy rights. For example, can I take out the image of now you see what is happening because of Grok. Now you are using the images of celebrities, distorting them. You are invading into their privacy. So publicity rights are a mix of personality rights are a mix of publicity rights and privacy rights. I need to protect my own image, my persona, and I should not be humiliated. My images should not be misused. Because if you do that, you're violating my right to life and dignity, which is a fundamental right under Article 21 of the Constitution. Let's look at the legal backing. We have Copyright Act. For example, I have written a song, I have composed music. Can you use this music without my authorization? No, because I have a copyright on this product. Intellectual property rights. I have sung a song. Can you use it on your YouTube channel without attributing it to me without my approval? No, you can't do that. So Copyright Act in India, they grant performers exclusive rights over my content. Similarly, there is a Trademark Act which permits individuals, celebrities, that distinctive persona about my identity, such as my name, my signature, even my catchphrases, trademarks, they are protected under the Trademarks Act. So for woolen products, there is a trademark. For silk products, there is a trademark. So this trademark is protected. And as such, you are protecting the personality rights. But listen to me carefully. What if there is an unregistered mark? For example, Mr. Jackie Shroff approached the Delhi High Court and it said, I have a trademark over my catchphrase, Bidu. So the mannerisms in which Sanju Baba walks, or Jackie Shroff speaks, or Anil Kapoor says, Jackass, although these are unregistered, they have not registered these catchphrases as trademarks. But under the Trademarks Act, there is something called passing off harm. So you're using these catchphrases to tell the people as if these people have endorsed your product. For example, you're listening to an advertisement on FM and somebody is mimicking Amitabh Bachchan or Jackie Shroff or Anil Kapoor. You will get a sense that Anil Kapoor, Jackie Shroff, Amitabh Bachchan have endorsed this product and we are a gullible audience, we will buy this product. Or somebody is using Jackass in this way, you will also get a sense that Anil Kapoor has endorsed this. Despite the fact that Jackass or Bidu, these are not registered trademarks, the court has said Trademarks Act also protects passing off harm, which means if you are using these catchphrases in such a manner that audience gets to get the sense that it is these celebrities which have endorsed this program, we will protect your trademark. And that is how Anil Kapoor's Jackass, Jackie Shroff's Bidu was protected under the personality rights. Asha Bhonsle, Ashwarya Rai, Alia Bhatt, various other celebrities have approached the court. Today, Bhuvan Bam has approached the court. So personality rights become very, very important. And what is their legal backing? The origin is the judgment of the court R. Rajagopal v. State of Tamil Nadu. So through this judgment, the Supreme Court has come up with an idea that there are personality rights And these personality rights, which means your name, your image, your signature, your voice, or the catchphrases that you use, or your images, it should not be subjected to unauthorized use and should not be subjected to intrusion as well. So thereby you are violating publicity rights and privacy rights. So personality rights are a mix of publicity rights and privacy rights. And these are safeguarded by the courts, although there is no one common law which protects them. Evolved through judiciary's judgment in R. Rajagopal v. State of Tamil Nadu 1994, and there are other laws which protect few aspects of personality, copyright, trademark, so on and so forth. Clear? Sir, can I go to the Supreme Court saying the ordinary law passed by the Parliament violates any other article of the Constitution but not fundamental right? Can you give me an example? Which right? Which article? Topic 17, bail in PMLA cases. So there is one principal law against money laundering called Prevention of Money Laundering Act 2012. And the agency which is responsible for all these cases is the Enforcement Directorate. Enforcement Directorate works under the Ministry of Finance. To be more specific, it works under the Department of Revenue, under the Ministry of Finance. Now, if I am accused of money laundering and I'm applying for bail, bail is very difficult. Bail is very strict. And bail can be granted to me if I satisfy what is known as a twin test. What is this twin test? If I am accused of PMLA, I cannot be granted bail by the court unless and until the court hears the public prosecutor. So without hearing him, I cannot be released on bail. And after hearing him, the court can grant me bail only if I satisfy two conditions. Condition number one, the court thinks, the judges assume that I'm not guilty. And the judges are confident that I will not re-offend. If there are reasonable grounds for the judges to believe that I am innocent, I am not guilty, and if the judges are convinced, there are reasonable grounds for judges to be convinced that I will not commit any offense if I'm on bail, then only can I be released on bail. Now you tell me, why would a judge release me on bail and why would he or she believe that I will not commit any offense? They don't know me, which means getting bail is difficult. You are asking for bail maybe before the trial starts. It is only after the trial starts that the judges will be presented with the evidence. There will be cross examination of the witnesses. Only then the judges will be convinced whether I'm guilty or innocent. Now, when the trial has not yet begun, when the witnesses have not been cross examined, when evidences have not been sifted through, how can the judges have reasonable grounds to believe that I'm innocent? That is why it's very difficult to get a bail in money laundering cases. But there are exceptions. Bail can be given easily to a person if you are less than 16 years of age, or if you're a woman, or if you're sick or infirm. You can be released on bail even if you don't satisfy the twin test. These are the things that you have to keep in mind. Are there similar tough provisions to get the bail in other laws? Yes. Which are these laws? Drugs and Cosmetics Act 1940. NDPS, Narcotic Drugs and Psychotropic Substances, in which Shah Rukh Khan's son was arrested. That is why he found it very difficult to get the bail. Also, Unlawful Activities Prevention Act 1961. I have discussed the denial of bail to Umar Khalid and Sharjeel Imam in one of the video. Please watch that video. That is why it is very difficult in these cases as well as in PMLA cases to be granted bail. But important thing is, Vijay Madan Lal Chaudhary v. Union of India 2022. Matter reached the court, and the matter was, how can you equate money laundering with terrorism? The maximum punishment for money laundering is 7 years. For terrorism, it can be death. It is very difficult to get bail in terrorism cases, but how can you equate money laundering with terrorism? Which means it is arbitrary and as such violative of Article 14 of the Constitution. Supreme Court upheld this law and said no. Financial terrorism through money laundering can be equated to terrorism. And these changes were made to Prevention of Money Laundering Act through money bill. So money bill becomes an important topic for your exam. How the money bill can be introduced. Can a private member introduce a money bill? Or can money bill be introduced only by a minister? Private member can also introduce a money bill. Or minister can also introduce a money bill. So revised money bill topic can also be relevant again in this year's examination. There is no limit in the constitution regarding money bill, whether it can be introduced only by a minister or a private member. Anyone, any member of the parliament can introduce money bill in Lok Sabha. Okay. But what Supreme Court has said recently in granting bail to Manish Sisodia and others, Supreme Court has said if you have spent more time in jail and the trial has not concluded, which means long years of custody, if you have spent considerable time in custody and there is no likelihood that the trial would end very soon, that's also a ground for bail. So normally what is the ground for bail in PMLA cases? If the court is convinced that there are reasonable grounds for us to believe that you are not guilty, we will release you on bail and you will not commit any other offense. If we release you on bail, that's when we can grant you bail. But the court has said that we will include one more provision. If there is a long incarceration, if you have been in jail for many, many years, for a considerable period of time, and the trial is not, there is no likelihood of the trial ending very soon, this is a ground for bail as well. And that is how K. Kavita was also granted bail, because she was a woman. Although the Delhi High Court had rejected her bail application, saying, you are a woman, but you're a different woman. Different woman in the sense you have been a member of the parliament, you're sophisticated. The Supreme Court came down heavily on the Delhi High Court, saying a woman is a woman. You can't be labeling women as sophisticated women or educated women or uneducated women. If there is explicit provision in the law that if a person is woman or a Sikh or less than 16 years of age, the court can grant the bail. The court should have granted the bail. This is topic number 17. Now, topic number 18, contempt of court. You have freedom of speech and expression, but there are reasonable restrictions. You can't be committing contempt of court. And contempt is of two types, civil contempt and criminal contempt. Can you file a criminal contempt case in the court? Yes. But what are the ways of filing it? Three things. The court can act suo motu. For example, in this lecture, I am criticizing the Supreme Court. I am scandalizing the Supreme Court. I am saying the judges are brutally corrupt. The judges are upper castes. They are derogatory towards the Dalits. Or the judges take money to deliver verdicts. Or the judges are incompetent. And maybe a judge is hearing this lecture, and tomorrow when the court opens, suo motu, on his own, the court will say, produce this individual before us. We want to proceed with criminal defamation against him because he's scandalizing the judiciary, or he tends to scandalize the judiciary. That's one way. Second, if Attorney General for India or Solicitor General for India approaches the court. Now, Attorney General or the Solicitor General will approach the Supreme Court. My lord, look at the lecture given by Sarmad Mehraj on Unacademy IS English YouTube channel. He is scandalizing the judiciary. If yes, contempt proceedings can be initiated against me. Third, any third person. Now, you have watched this lecture. You go to the court that this person has committed contempt. We want you to take action against him. The court will not accept your petition. The court will ask you, go to Attorney General for India or Solicitor General of India and ask for their written approval. You will have to go to Attorney General or Solicitor General. They will look at this video and then they will decide whether this is a fit case for contempt or not. If it is not a fit case of contempt, I will not give the approval. If it is a fit case of contempt, I will give you the approval and then you can approach the court. Why is this provision, third provision there? It is to save the time of the court. Otherwise, any random Tom, Dick, and Harry will approach the court and file contempt petitions. We need to trust Attorney General for India. Only if you vet these petitions and tell us whether these are fit cases for contempt or not, only then we will accept. Contempt of court cases filed against numerous individuals in the last 1.5 years. That is why this topic is important, relevant for your examination. Now, there are two more important topics that we need to discuss. Please stay with me. Two very important topics. Who is a lawyer and who is an advocate? Anyone who has the knowledge of the law, who has completed the law course, is a lawyer. But only those lawyers who are enrolled in the bar under the Advocates Act of 1961, they are called advocates. So whoever has the knowledge of the law, has completed LLB course for that matter, is a lawyer. But maybe you have completed LLB course, but you're not practicing law. You are doing your business, or you're preparing for the Civil Services Examination. You're only a lawyer, you're not an advocate. But if you register under the Advocates Act of 1961, now you can plead before the court. You are an advocate. That's the difference between the two. But listen to me carefully. There is something called privileged communication. You are an individual, you have a case, and you want my assistance. I am the advocate. That please file my case, fight my case. Maybe you have committed murder, or you're accused of murder, or you're accused of rape, or you're accused of money laundering. Now, whatever you will share with me, it is a privileged communication. What has happened recently is that ED or police is asking lawyers to be present, advocates to be present and participate in the investigation, cooperate in the investigation. What legal advice have you given him? Matter went to the court. My lord, this is a privileged communication. Why are investigative agencies asking advocates to appear before them and reveal what is the advice that they have given to their clients? There is something called privileged communication. This privileged communication is part of some protected relationships. For example, attorney-client, spousal relationship. How? For example, Section 128, communications during marriage. Husband and wife, they're discussing a lot with each other. And now the police is investigating the husband. Can the police compel this wife to give evidence against this husband? Whatever you have shared with each other? No, because this is part of their spousal relationship and as such protected. So whatever has been communicated to each other during the course of marriage, that is all protected. You cannot be revealing this unless and until, of course, you want to divorce each other or you have committed a criminal offense, then you have to reveal this information. Otherwise, no. Similar protection is available to Lawyers and clients. Lawyers, advocates, and clients. Can an advocate be compelled to reveal what advice you have given to the client? No. But there are some exceptions. Bharatiya Saksha Adhiniyam, which replaced Indian Evidence Act, it prohibits an advocate from disclosing any communication made to him in the course of professional engagement, even after the employment has ceased. So I was your advocate 2 years ago. Now I'm not your advocate. Even now, I cannot reveal it to anybody what we communicated with each other, because this is part of privilege protected communication. Except if you consent to it. If you say, okay, reveal it to the police, I will reveal it. Or if this communication is related to illegal purpose, something illegal was done, I have to reveal it. Or if the advocate observes that when I was advising you, you resorted to criminal activity. You laundered money. I will have to tell the police or ED that you laundered money and I have the evidence of that. Otherwise, what advice I gave you, how to resolve your disputes, how do we tackle these cases? These are part of protected privileged communications. Matter went to the court. Supreme Court took it on suo motu. That means on its own, when lawyers were being asked by investigative agencies to appear before them and reveal what communication you have had with the client, Supreme Court took the matter onto itself. Supreme Court said, see, on one side there is section 132 of the BSA, Bharatiya Saksha Adhiniyam, the Indian Evidence Act. On the other hand, we have Article 20, Clause 3. No person shall be compelled to become a witness against himself. So if we marry the two protections, this protects the client attorney relationship. Attorney cannot be forced to become an evidence, to become a witness against the client. So if you're coercing the lawyer to disclose confidential communication, that would violate fundamental rights as well. But in this case, look at the question on your screen. All advocates are lawyers, but not all lawyers are advocates. Both advocates as well as in-house counsels enjoy client-attorney privilege of the same type. What is the answer? All advocates are lawyers, but not all lawyers are advocates. Correct. Advocates have the knowledge of the law, they are lawyers. But only those lawyers who are registered with the Bar Council under the Advocates Act, only they can practice before the court. So not all lawyers are advocates. Both advocates as well as in-house counsels enjoy client-attorney privilege of the same type. A, only one. Sir, who is an in-house counsel? Listen to me carefully. We know who is a lawyer. We know who is an advocate. Now, who is an in-house counsel? Companies, for example, Unacademy, we have a group counsel, GC. Advocate, has a law degree as well, but he is an employee of Unacademy. Clear? Now, the communication between employer, Unacademy, and this employee group counsel, will it also come under attorney-client privilege? No. Why? Listen to me carefully. You are my client, I am your advocate. If you ask me to do anything illegal, I will not do it. I'll say, go find a different lawyer, because I have independence to either accept your case or reject your case. But you are my employer. I am your employee. Can an employee say no to an employer? No. For example, I am told by my employer that you have to promote an academy revision test series, which is available for 1999 for all the students. Can I say, no, I don't want to do this? No, I can't say that. I have to promote it. So there is no degree of independence for an employee. And that is why if an in-house counsel, who is a group counsel, he does not enjoy the same attorney-client privilege as is for an attorney and a client. That's the key difference that you have to keep in mind. So this time, what the court clarified who is a lawyer, who is an advocate, and this attorney-client privilege is for an advocate and the client, but in-house counsels, they don't enjoy the same privilege, which means in-house counsels, whatever communication that they give to their employer can be investigated and can be called into action as well. Now comes an important case. Who is an advocate on record? These are the people who can list cases before the Supreme Court. They have to take a special examination of Supreme Court, and only those who are the advocates on records who qualify this exam, they can list cases before the Supreme Court. Then who are the senior advocates? They plead before the court, but can they directly talk to the clients? No. Who is directly interacting with a client? Advocate on record. So advocate on record is directly in touch with the client, gets all the papers ready, listed before the court, but who argues before the court? Senior advocate. But can any case be filed in the Supreme Court without advocates on record? No. Does a senior advocate liaison with the client? No, it's not allowed. So senior advocates, they plead before the court, but they do not interact with the clients. They can't solicit the clients. It is the advocate on record who presents all the papers, all the case files before the Supreme Court. And without him, no case can be filed in the Supreme Court. This is another important matter which you need to keep in mind. And now the last topic, National Human Rights Commission. There was some guideline issued by National Human Rights Commission. I think recommended 10 lakhs or 20 lakhs for someone who was tortured to death in custody in Uttar Pradesh. So NHRC becomes important. NHRC is a statutory body. Statutory body means it is a body which is enacted based on the law passed by the parliament. And which is that law? Protection of Human Rights Act 1993. And this body was established in 1993. And this National Human Rights Commission provides for National Human Rights, this Act, Protection of Human Rights Act. It provides for the creation of NHRC, State Human Rights Commission, and Human Rights Courts. These three things you have to keep in mind. So this law, which was enacted by the Parliament in 1993, it is based on Paris Principles. Paris Principles were adopted by the United Nations, saying we need national institutions in different countries which can promote, protect human rights of the people. Otherwise, the state can violate human rights of the people. We need independent institutions, autonomous institutions to uphold, protect human rights of the people. These principles were adopted by the United Nations General Assembly, and ultimately a law was passed in India in 1993. This law provides for National Human Rights Commission at the national level, State Human Rights Commission for every state, and human rights courts. Who is the chairman of the NHRC? Previously, the chairperson of the NHRC could only have been an ex-Chief Justice of India. But in 2019, the law was changed, and the law said now the chairperson of the NHRC can be an ex-Chief Justice of India or a judge of the Supreme Court or an ex-judge of the Supreme Court. So not necessarily a retired Chief Justice of India. What is the composition? We have the National Human Rights Commission's chairman, who is the former Chief Justice or former judge. One member is the judge of the Supreme Court. One member is the former Chief Justice of a High Court. And there are three members, at least one member should be a woman. But then there are ex officio members. That means by virtue of you holding that office, you automatically become part of the NHRC as well. If you are the chairman of the National Commission of Scheduled Castes, National Commission of Scheduled Tribes, National Commission for Women, National Commission for Backward Classes, National Commission for Minorities, National Commission for the Protection of Child Rights, Chief Commissioner of Persons with Disabilities, Whoever is holding these positions, you are automatically part of the NHRC. These details you have to keep in mind. Originally, that means before 2019, the chairperson and members of NHRC as well as State Human Rights Commission would hold office for 5 years or till the age of 70, whichever is earlier. So they would be holding office for 5 years or till the age of 70, whichever is earlier. Now in 2019, their term was reduced to 3 years. The original act before 2019 said if these members were appointed to NHRC, for example, these are the members of NHRC, they are appointed for, let's say, 5 years. Can they be reappointed? They can be reappointed for a period of 5 years. In 2019, the law changed, and law said the changed law, the amended law said, can they be reappointed? Yes, but removes the 5 year limit, which means can these members be reappointed? Yes, but previously they could be reappointed for 5 years. Now they can be reappointed for 1 year, 2 year, 3 year, 4 year. So this 5 year limit has been removed. What are the key functions of the NHRC? It has the power to investigate. It can even ask police to assist them in investigating a human rights case. It will advise the government on policies related to human rights, related to effective implementation of human rights. It can monitor jails, prisons, and other bodies to ensure that human rights are not violated. It has promotional role. It will promote research in the field of human rights. And that's how NHRC organizes seminars, workshops to promote human rights, popularize human rights. An annual report of NHRC is presented to the central government. It is not presented to the president. It is submitted to the central government. It is submitted to the Ministry of Law and Justice. And if required, this report of NHRC is acted upon. But whatever recommendation of NHRC is, this recommendation of NHRC is not binding. These are the facts that you have to keep in mind. So today, in less than 2 hours, we discussed 20 important topics of current affairs relevant for your prelims examination. But I also understand that a major chunk of questions asked in the prelims examination may sometimes be from current affairs of January 2026 onwards. And for that, in the last stage, the fifth stage, we will cover current affairs of the period January till April 2026. So today, as well as yesterday, we discussed important current affairs topics which appeared in news during the period January till December 2025. And if you got benefited from these sessions, do let me know in the comment section and do not forget to subscribe to our channel. Thank you for watching. I'll see you again next time. Till then, have a great time. All the best. Good night.